Legislation enacted shortly before the 2008 election, with the support of then Senator Obama, largely changed the FISA court. The government can now collect communications simply by declaring it is doing so for reasons of national security. And the law grants total immunity to telecom companies accused of surveillance wrongdoing in the past and the future. All a company has to do is to present in court a written request from the administration that engaged in activities at government request. How odd this is. The government is advocating immunity for something, wiretapping, that it insists is not a crime. Shortly before a federal appeals court in California decided a case against telecoms, alleging that they gave the government access to databases, including records of phone calls and websites visited. One of the lawyers was required to write his brief in a windowless government office without any notes or books under the eyes of 2 security guards. When he said he was hungry, he was brought a banana, and when he finished it, the peel was shredded. In court, for literally the 40th time, the government asserted that the state secrets privilege prevented it even from saying whether a warrant was obtained. This privilege, very simply, no gobbledygook, no legoop here, asserts that any discussion at all of a lawsuit's accusations, even before a judge in secret session, endangers national security. One judge said, the government declares that it is a state secret. That's the end of it. No cases. The king can do no wrong. The court upheld the government's state secrets claim, but sent the case back to the lower court judge. And that judge has since ruled that the government illegally wiretapped the lawyer's conversations with a now defunct Saudi Arabian charity called Al Aramain. The judge asked the government to produce a warrant, but it refused, since that would mean opening the can of state secrets. It all reminds me of the movie Animal House, where the dean put a fraternity on double secret probation. It doesn't know the rules, or even that it is on probation, so it can never get out of it. And where does the Obama administration stand in all this? Alas, in the same shoes as the Bush administration. It has taken exactly the same positions, nearly across the board. The only difference is that it has said almost nothing about any of this. It has, after all, had a few other things to deal with. I come now to the question you all have been waiting for. Is the government spying on you? And the answer is yes. A series of interrelated operations, unprecedented in size and scope, combines foreign intelligence gathering with domestic eavesdropping and data collection. The NSA has not only collected the records of all calls, it has worked with Silicon Valley companies to improve data mining techniques. One company, Virage, whose products can transcribe audio conversations, boasts that the NSA parent agency is a customer. Our texts and emails have been gone through, searching for specific words and patterns. I don't know how many emails and texts have been sent, although I am sure that those in this room feel they have sent most of them. But since late 2001, more than 5 trillion phone calls have been made in this country. Connecting the dots in data mining is difficult, as everyone knows, but the real trick is figuring out where the dots are and which ones need connecting. What happens if the government heard someone say on the phone, until this past May, what do you think of what bin Laden did? That person would probably be placed on the surveillance list, and all of her or his future conversations would likely be flagged, listened to, and probably transcribed. This could also happen if you're talking about shipping, and you say the bin is laden with widgets. A false positive is created, which is the trouble with tracking. If one assumes that an emergency justifies the restrictions of constitutional rights, and that the rule of law does not bind the president when he, or in the future she, acts as commander-in-chief, very little is left to restrain the president. The Bush administration explicitly argued that the use of force resolution Congress passed in the wake of 9/11 permits the NSA to wiretap, regardless of the FISA law. History would be a wonderful thing, if only it were true, wrote Tolstoy. But no member of Congress has ever said that wiretapping was in his or her mind when voting on the resolution. The theory of wartime executive omnipotence could equally justify mail opening, which is legal under the FISA law and has already happened. Burglary, torture, or internment camps, all in the name of gathering foreign intelligence. Unless rebuked, it will lie around like a loaded weapon, ready to be used by any president who claims an urgent need. A president would have the power to restrict our privacy, monitor our conversations, and limit the rights of all for the duration. For burglary, we might not have to wait. Consider an attempted black bag job in Portland, Oregon. A lawyer named Thomas Nelson represented Solomon Al-Buthay, who was indicted for taking out of the country donations to the Saudi Arabian charity I mentioned earlier. He told the local U.S. attorney that twice, late at night, a non-Hispanic white man was in his office wearing an apron and a badge and claiming to be a member of an otherwise all-Hispanic cleaning crew. 3 months later, the same man, this time waving a Brillo pad, tried to open the lawyer's locked office door. His home alarm system seemed to keep continually malfunctioning, but his security company could find nothing wrong with it. The National Security Agency told Mr. Nelson that even the possible existence of a response is classified. That is the difficulty with fighting shadows. How can you defend against what you cannot see? Make no mistake, intelligence on terrorists and terrorist groups, wherever they are, is indispensable. For all intents, the government can legally wiretap at will, and you will never know. In a similar spirit, the Patriot Act permits the FBI to mine commercial databanks without probable cause. This could mean that agents might show up at the doors of people who order politically unpopular books on Amazon.com, or who merely contact organizations critical of any administration in power. This has happened, but the Patriot Act makes it a crime to, quote, tell any other person. That seems to include one's spouse, and also one's lawyer, who, after all, is a person. FBI undercover agents searching for terrorism can attend all public gatherings and enter churches, synagogues, and mosques, since they are open to the public. But a spy paid by the FBI infiltrated a mosque in Orange County, California, and suggested that those in attendance should engage in criminal activity. This is now in court. The Patriot Act also allows the FBI to keep under surveillance as a trespasser anyone who accesses a computer without authorization, anyone at work who buys something personal or sends an email to a friend, or it could be someone who violated an internet service provider's policy simply by being late with payments. I hope it does not include students who use college computers for other than the strictly educational purposes we all know they're put there for. The war on terrorism has quickly brought the struggle for privacy online to a head. All broadband and voice-over internet protocol providers must now provide the same wiretapping capabilities as conventional phone companies. This is very much like giving the police the keys to your house, just in case they need to see what's going on inside. But this may be unnecessary now, since the FBI has developed a point-and-click surveillance system that performs instant wiretaps on almost any communications device. And the National Security Agency has said that it will monitor and surveil all online activity without warrants, if necessary. The Obama administration will shortly ask Congress to pass a law requiring all communication services to retain records of all online activity and to be able to unscramble encrypted messages on BlackBerries, Facebook, and Skype.